I'm Domenick Calabrese. Since 2003, I've been a Connecticut probate judge. And since 1995, I've been a Connecticut attorney practicing in the areas of estate planning, probate, asset protection, and business. In my series, Practical Probate, I'm going to talk about the importance of estate planning. Every day I see the problems and stress that families endure due to a lack of proper estate planning. But I also get to see how a proper estate plan can greatly reduce the uncertainty and hardship when a loved one becomes incapacitated or passes away. Estate planning is a subject that's easy for people to forget about. However, if you don't plan your estate and plan for potential legal incapacity, there can be dramatic consequences both for you and your loved ones. Proper estate planning will increase the chance that your assets will go to the people you want them to, or the organizations of your choice after you pass away. It also can ensure that your loved ones will be provided for. The possibility of incapacity is real and far more significant than most people realize. Incapacity can strike suddenly and without warning, a very stressful situation for the person who's incapacitated and their families. And that stress is only increased if there's not a plan in place. Proper legal tools for an estate plan can greatly reduce the stress, uncertainty, and the need to go to a court in order for your family and your own personal business to continue to be taken care of. However, there are unscrupulous purveyors of estate planning products who frequently claim or imply unrealistic or even false results. They prey on the fear of the probate process, on fear of the unknown, and unfamiliarity with the law in order to sell their very expensive estate planning products that frequently don't deliver on the promises that they make. Some of the topics I'm going to be talking about in the coming videos are estate planning, planning for incapacity, choosing the right attorney, estate planning myths, misconceptions, and mistakes, wills, living trusts, pet trusts, incapacity, conservatorships in the probate court, powers of attorney, and unclaimed property. Welcome to this edition of Practical Probate. I'm Domenick Calabrese. I've been a Connecticut attorney since 1995 and a Connecticut probate judge since 2003. Today I'm going to talk about estate planning. The information in this presentation is not intended to be legal advice and should not be relied upon as legal advice. For legal advice as to your own situation, you should consult with a qualified attorney. The purpose for this presentation is simply to give you information to better enable you to make decisions as to your own situation. Estate planning covers a lot of ground and can be very complex. Today, I'm going to look at the objectives of an estate plan, obstacles to estate planning tools, incapacity, estate tax, providing for loved ones, charitable giving, and control over asset disposition. So the objectives of an estate plan are to maintain control over your assets and your affairs and to maintain independence, particularly should you become incapacitated. The idea behind an estate plan is to be proactive, to plan in advance, to plan for the inevitables like death and taxes, and to plan for things that are not necessarily inevitable but are likely or possible to happen, such as creditor issues and legal incapacity. Other estate planning objectives include minimizing estate taxes, providing for your loved ones, giving to your charities, the charities of your preference, control over what happens to your assets, and other items that we're going to talk about later on in this presentation. Given the importance of estate planning, it's probably surprising to know that most Americans don't have an estate plan. In 2016, a study looked at some of the more common reasons why Americans fail to plan. One reason was the misconception that estate planning is only for the wealthy. Certainly, the wealthy should have an estate plan, but it's even more important for people of more modest means to have an effective and updated estate plan. Another reason cited by the people who participated in that 2016 study for why they didn't have an estate plan was their inability to find a trustworthy advisor or attorney. There's a perception that estate planning can be complex, and that keeps many people from taking that first step to create their estate plan. And of course, there's emotion involved in estate planning. Obviously, we're talking about death, we're talking about people becoming incapacitated, and those can be very difficult emotionally to deal with. There's also the perception of the high cost of estate planning. But I can tell you, particularly from all my years on the bench, that not planning for your estate is actually more expensive than spending some money with a qualified attorney to create an estate plan. And it's easy to put estate planning off because it's invisible unless and until the events like incapacity or death occur. So let's look at some estate planning tools. The first category of tools we're going to look at are those tools that are used to plan for incapacity. Some of those tools are trusts, powers of attorney, advanced healthcare directives, also known as living wills, the appointment of healthcare representatives, an advanced designation of conservator, and entities such as limited liability companies and corporations. The next category of tools for estate planning fall into the area of managing one's assets. And the tools in this area include wills and trusts and different forms of ownership, such as owning something only in your own name or having something with a beneficiary designation or in survivorship. So let's look at the area of life. During your lifetime, during incapacity, and then after one passes away. And I'm going to look at the different tools that are commonly used in an estate plan and talk about where they have utility along that continuum. The first area, of course, is when someone passes away. At death or after death, the one tool that most people think about is a will. And certainly a will is an important part of any effective estate plan. But a will only has utility after someone passes away and after the will is admitted to a probate court or surrogate's court. Until that happens, a will has no utility, and a will certainly has no utility in managing someone's assets during incapacity. The next set of estate planning tools are advanced directives and the appointment of healthcare representatives. Those tools are effective only should someone become incapacitated and they're unable to communicate with their healthcare provider. The next common estate planning tool is a power of attorney. A power of attorney, which I'm going to talk about in more detail in a few minutes, allows someone to designate a trusted person or persons who can make decisions for them in certain areas that are outlined in the power of attorney document. And a power of attorney is only effective while the grantor is alive, including should the grantor become incapacitated. The last tool that I'm going to talk about is a trust. A trust is the only tool in the estate planning armamentarium that's effective while you're alive, should you become incapacitated, and after you pass away. For that reason, a trust can be a very powerful and effective tool, and indeed is the foundation of many estate plans. Let's take a closer look at planning for incapacity. The objective when one plans for incapacity is to provide for the management of your affairs when you are not able to do that yourself. It's also to avoid court intervention with a conservatorship or a guardianship. Remember, if you are the subject of a conservatorship or guardianship proceedings, they can be costly, time-consuming, and stressful. And inevitably, if the judge grants the petition to appoint a guardian or conservator, some or all of your rights to make decisions for you, for yourself, will be taken away from you. That's something that you would really like to avoid. The likelihood of disability, and disability, of course, is a category that includes incapacity. Not everyone who is disabled is incapacitated, but everyone who's incapacitated is disabled. And it's very likely, far more likely than most people realize, to strike people, even fairly young people. And studies show that 1 in 4 of 20-year-olds, today's 20-year-olds, will be disabled before they retire. And right now, about 12% of our population in the United States, 37 million Americans, are classified as disabled. More than 50% of disabled Americans are fairly young. They fall into the age category between 18 and 64. So it's not just a situation with seniors, it can happen to anyone. And to look at it a bit more closely, a 35-year-old healthy female has about a 1 in 4 chance of becoming disabled for 3 months or longer during their working career, and there's a 38% chance that that disability is going to last 5 years or longer. But if you add tobacco use and a 160-pound body weight to that equation, there is now a 41% chance of that woman becoming disabled for 3 months or longer. For men, there's a 21% chance of becoming disabled for 3 months or longer for a 35-year-old healthy male, and there's a 38% chance that that disability is going to last 5 years or longer. Now add tobacco use and a 210-pound body weight, and those numbers increase dramatically. The risk of becoming disabled for 3 months or greater is going to be up to 45% for men. And remember too, with the body weight factor, 2/3 of Americans are overweight or obese. So we are really talking about a very significant part of the population and the likelihood of disability. So how can you plan for incapacity? Well, one of the tools you can use to plan for incapacity is a trust. A trust allows for the management of assets that you place into the trust while you're alive. That's an important step that a lot of people don't bother to take, even if you become incapacitated. It also provides for what happens to those assets in the trust after you pass away, effectively avoiding the probate process. A power of attorney is another important tool that's often used in an incapacity plan as part of an estate plan. And a power of attorney allows you to name a trusted adult or one or more adults to conduct your financial affairs, whatever financial affairs you put in that power of attorney, during your incapacity. And indeed, even if you're not incapacitated, the agent under that power of attorney is able to make those decisions. So you need to be careful with who you give that power of attorney to. An advance directive or living will is a tool that's used to let your healthcare providers know what measures you want or you don't not want should you become so sick that your chances of recovery are deemed almost non-existent. That's a way of letting your healthcare providers know what measures you want and you don't want in that situation. Measures like CPR, measures like artificial respiration, artificial means of nutrition and hydration. Another tool that can be used in planning for incapacity is the appointment of a healthcare representative. It's also known in some states as a healthcare surrogate, but this is a way for you to authorize a trusted adult to make healthcare decisions for you, but only if you're not able to communicate with your healthcare provider. If you can communicate with your healthcare provider is going to do what you direct them to do. But if you can't, your healthcare representative will have that authority. It may prevent the need for a conservator or guardian of the person, and it does, in Connecticut at least, have priority even over a conservator of the person who's given authority to make healthcare decisions. Another objective to estate planning is minimizing death taxes. Death taxes on the federal level include estate tax, gift tax, generation skipping transfer tax, and income tax. In Connecticut has an estate tax, an income tax, and a gift tax. And for those who passed away before January 1st, 2005 in Connecticut, there was also a succession tax and generation skipping transfer tax. But I'm not going to talk about those two death taxes in this presentation. In an estate plan, you want to minimize your estate tax liability by preserving the individual exemption or lifetime exclusion for married couples for the first spouse to pass away, and essentially reducing the net taxable estate, preserving more of your wealth for your loved ones. Some of the tools that are used to minimize estate tax liability in an estate plan are trusts. There's a portability element in the federal estate tax law, which allows, after the death of the first spouse, the surviving spouse to basically take the deceased spouse's unused lifetime exclusion, what remains of it, and carry it forward. This is not available, though, in most states that have estate taxes, including Connecticut. In Connecticut, the only way one can preserve that exclusion is by using trusts. There's also wills, lifetime gifts, and charitable giving as means of minimizing estate tax liability. Now, providing for loved ones is a very important objective for almost anyone, including those who put estate plans together or are interested in creating an estate plan. And the way one does this is by wills, trusts, entities like limited liability companies and corporations, and lifetime gifts. Ownership of assets is another way to provide for your loved ones. So you can take, for example, an account in a financial institution and say that it'll be payable on death to maybe your adult children or to your spouse, for example. You can put property in survivorship, which basically says that when one owner of that property passes away, the remaining owner or owners will automatically get that asset by operation of law without having to go through the probate court. A third way to do this is with a beneficiary designation. Beneficiary designations are common in life insurance policies and retirement accounts like IRAs and 401ks. The objectives in providing for loved ones include outright bequests, estate management. For example, you may want to provide for a family member who has special needs, or someone who is youthful and maybe does not have the ability or experience to manage a large asset at a young age. Those who have issues with creditors, you would want to make sure that your loved one who has creditor issues is able to get those assets and use of those assets, but prevent their creditors from getting at those assets. And those in unstable marriages, you would want to make sure that your loved one is provided for, but that family assets are not used as part of a divorce settlement. You may also want to provide for successive generations. You may want to provide, for example, for a grandchild or grandchildren's college education. You may want to give your children the use of certain assets, but after your children pass away, you would want them to pass along to successive generations like your grandchildren. So all of these objectives are commonly sustained or obtained in an estate plan. Charitable giving, giving to charities of your choice, is another common objective in an estate plan, and you want to ensure that assets are transferred to the charities of your choice, either through a will or a trust, and that also reduces your taxable estate because transfers to charities, to qualified charities, are deducted from the calculation for estate tax liability. If you don't plan, if you don't have an estate plan, you are not going to have control over what happens to your assets when you pass away. And oftentimes people have a misperception of what the state law is in terms of who gets your assets when you pass away. For that reason, it's not uncommon for a family member, a distant family member, or a family member who has been out of the picture for many, many years to end up getting some of your assets when you pass away. When you put an estate plan together, you can avoid that. You can also use asset protection in your estate plan. Asset protection is simply a way of arranging assets to maximize their value for you and your family in the face of creditor attack. And there's a number of tools that can be used in asset protection, like limited liability companies, corporations, and trusts. And I'm going to talk about asset protection in a separate presentation. Certainly, an estate plan needs to be updated on a regular basis, a minimum of every 3 years. The laws change on an almost constant basis, and your situation is likely to change as well. For that reason, it's important to sit with an estate planning attorney and update your estate plan, or at least review it to make sure that it still reflects your objectives and is still consistent with the laws of the state and the federal government. You would also want to update your estate plan after significant life events like marriage, divorce, the birth or adoption of children or grandchildren, the death of a spouse, or a significant change in your own health or finances. Important factors in an estate plan include the value and type of assets you own, what your values and objectives are, because everybody has different values and objectives. And I'm not a fan of one-size-fits-all estate planning for that reason. A good attorney is going to sit with you, take time to understand your values and objectives, your asset situation, your family situation, and then give you options as to how you can put your estate plan together to empower you to participate in your estate plan. That's a good way of ensuring that the estate plan you have is the best estate plan for you, and you have some level of understanding of it. Estate planning is not an area where you should do it yourself. You should only do it with a qualified estate planning attorney who devotes a majority of their time to the practice of estates and trusts. I suggest that you avoid attorneys who practice in many areas, because this is a very complex and constantly changing area of the law. I would also advise you to beware of living trust scams. There's a lot of living trust scams going out there. There's unscrupulous purveyors of these questionable products that often charge thousands of dollars for them. And the purported benefits of these plans oftentimes don't pan out. I've seen it as a probate judge for 17 years, so be very careful and be very wary about anybody who's trying to sell you something, particularly if they're trying to prey on your fear of the probate process or fear of the unknown. If you feel pressure to purchase a product, run the other way, because that's not going to be the right person for you to put your estate plan together with. Beware of fear, false evidence appearing real. You should be comfortable with your estate planner. You should only use a qualified estate planning attorney. And in a different presentation, I will talk about how to choose an attorney. In conclusion, everybody's situation is different. Your situation is different from your neighbors and your cousins and your coworkers. Discuss your situation with a qualified estate planning attorney and avoid those who propagate fear of the probate process in order to sell prepackaged, one-size-fits-all living trust plans.